This is Bloomberg Law.
What does a prosecutor have to prove in order to get a RICO conviction? Tell us why the Solicitor General is sometimes referred to as the 10th Justice.
Interviews with prominent attorneys and Bloomberg legal experts.
That's Jennifer Kay for Bloomberg Law. Joining me is former federal prosecutor Robert Mintz.
And analysis of important legal issues, cases, and headlines.
Is the toughest hurdle for prosecutors proving Trump's intent? Alito took on Congress, saying Congress has no power to regulate the Supreme Court.
Bloomberg Law with June Grasso from Bloomberg Radio.
Welcome to a special Best Of edition of the Bloomberg Law Show. Ahead in this hour, Donald Trump looks for a get-out-of-jail-free card. The Supreme Court grapples with whether public officials can block citizens on social media. And what exactly is a legal hot tub?
That's what makes these cases hard, is that there are First Amendment interests all over the place.
And not only are there First Amendment interests all over the place, as Justice Elena Kagan put it, but the justices' questions seem to be all over the place as well, as they considered whether public officials can block citizens on social media. The two cases involve school board members in San Diego and a city manager in Michigan who blocked followers on social media. Of course, evoking discussion of former President Donald Trump's efforts to block people from his Twitter account.
I mean, I don't think a citizen would be able to really understand the Trump presidency, if you will, without any access to all the things that the president said on that account. It was an important part of how he wielded his authority. And to cut a citizen off from that is to cut a citizen off from part of the way that government works.
The central question is whether the social media activity constitutes state action, making it subject to the First Amendment. And the federal appellate courts in the cases came to opposite conclusions. The justices presented a host of social media scenarios to the lawyers. Here are Justices Sonia Sotomayor and Brett Kavanaugh.
So let's assume a mayor says, I'm setting up a hotline for emergencies on my Facebook or Twitter. And if you have an emergency, call that hotline, and I will use the power of my office to set in motion government response for your emergency. Seems to me that that's government action, isn't it?
But suppose the city manager on the personal site says, we have new recycling rules. You have to use a blue bin, has to be at the curb, will be picked up on Wednesdays. If you have any questions, contact me. That's only on the personal site, not on the official site. Is that state action?
Joining me is Professor Eric Goldman, co-director of the High Tech Law Institute at Santa Clara University Law School. Eric, explain the main issue in these cases.
The core issue is what should happen when government officials maintain social media accounts? Can they treat it as if they're ordinary citizens, or are they governed by the rules that apply to government generally?
And are the issues in the two cases before the court basically the same?
They're basically the same. There are little details about exactly how the particular government officials were using their social media accounts that might matter to the final conclusion. But the core questions the court's asking and the legal tests it's likely to adopt are probably going to be the same.
So let's talk about the concerns of some of the justices. And Justice Elena Kagan said there are First Amendment interests all over the place.
I thought that was a really great line, honestly. Justice Kagan has just such a great way of turning phrases, and she's absolutely right. There are First Amendment considerations on all sides. It's not like there's an easy path forward that balances all the respective interests. On the one hand, people who work for the government should be free to engage their communities and express themselves publicly as private citizens. That's the constitutionally protected right. They don't give up that right by going to work for the government. On the other hand, when the government controls online discourse spaces where people are talking to each other, there's a really real and significant risk of censorship. And so the concern is that if the government officials can act like private individuals, they can functionally censor conversations. Now, if they're acting as a private individual, they're allowed to do that. But if they're acting as a government, they're not. And so either we're going to circumscribe the free speech rights of government employees, or we're going to allow government employees to circumvent the free speech rights of the people who want to engage with them. Somebody's going to lose something here.
Yeah, so Trump came up naturally, and Justice Elena Kagan said Trump was conducting a lot of government on his Twitter account. It's an important part of how he wielded his authority, and to cut a citizen off from that is to cut a citizen off from part of the way the government works. And in these local cases, it's just as important for constituents to hear what their school board members are saying or their town managers and the like.
It's not just to be able to hear what the government officials are saying, but also to be able to talk back to them, and even more importantly, in certain circumstances, be able to talk to each other as constituents or as citizens that are responding to the posting of a government official. And so when a government official exercises some of the tools that are provided them via social media to control conversations, what they're really doing is distorting the conversation that citizens might want to have with each other.
So I don't know why. To me, it seems like, if you're posting public information on a website, on a Facebook page, that should be open to the public and the public able to comment. And if you want not to do that, then have a private page as well.
So certainly those ideas came out. In fact, there are 3 different categories of pages that a government official might have. They may have a official government page. They may have a campaign page, which is not part of their official government duties, but still is an important place for them to evangelize the work they're doing. And they may have a personal page that has nothing to do with their role in government. And figuring out which account is in which category is something that is baffling to us as citizens when we see our government officials online. And it's also vexing to the government officials because so often they want to take their victory laps. They want to evangelize their work, to tout their successes. And we aren't sure, are they touting them as official government policy, as a campaign promise, or just because they're touting their own work as a private individual. And the court didn't know how to approach that issue. They understood the trade-offs, but there was no clear way to move forward that was going to satisfy everybody.
So I want to get your reaction to what Justice Amy Coney Barrett said.
I think it's very difficult when you have an official who can in some sense define his own authority. So I think for a governor or, President Trump, it's a harder call than someone like a police officer who's a subordinate. Or I could, my law clerk could just start posting things and say this is the official business of the Barrett chambers, right? And that wouldn't be okay. But if, that wouldn't be okay.
That comment got a laugh, of course, but what do you think about the content of what she's saying?
I mean, the exact example she gave was kind of weird because a clerk wouldn't be likely to be able to set up and speak on behalf of their judge that employs them. So that was a weird example. But the broader principle is 100% correct, that the court is trying to figure out how do they simultaneously govern the top of the political hierarchy, like a president or a governor or even a mayor, someone who's at the top of the organizational pyramid, and all the people who are rank-and-file government employees, some of whom might also be able to speak on behalf of the government, others of whom have no real legitimacy to do so. And the Supreme Court is struggling to figure out how can we come up with one rule that covers all of those different types of job responsibilities and status in the hierarchy. And it's possible that they cannot come up with a single rule that will cover it. They may need multiple rules that will have to be iterated over time.
So you think that there's no clear legal test that they could come out with?
Honestly, no, there is no clear legal test, and I think we can be a little bit more emphatic that the different considerations include things like what's the employee's job and what tools are available in social media to be able to control conversations, and which of those tools was wielded, and how did the person describe or characterize their account, and how much of the account was used with official related postings versus personal postings. Like, we need a multi-dimensional matrix to try to figure out where to place all the different nodes in those questions. And that's why even with 2 cases in front of the Supreme Court that they can use to compare and contrast, they still don't have enough cases to cover the full range of facts that are going to be implicated by their ruling.
Coming up, we'll discuss whether there was any consensus on the court. I'm June Grasso, and you're listening to Bloomberg.
This is Bloomberg Law with June Grasso from Bloomberg Radio.
You're listening to a special Best of edition of the Bloomberg Law Show. Joining me is Professor Eric Goldman of Santa Clara University Law School about Supreme Court oral arguments over whether public officials can be sued for restricting access to their social media feeds. It's the first of several social media clashes this term. The first case involves two San Diego area school board members who set up Facebook and Twitter pages during their 2014 campaigns, then continued using the sites to talk about school issues after winning election and taking their seats. They set up their pages so that their posts were open to comment by members of the public. Two of their constituents left frequent comments criticizing the board, and the school board members eventually blocked them. The second case involves a city manager in Michigan who used his Facebook page to post both family and professional information. His posts in 2020 about the COVID-19 pandemic drew a series of critical comments from a follower who he then blocked. Federal appeals courts reached opposite decisions in the cases, and now it's up to the Supreme Court. So how about the idea that was floated by Justice Ketanji Brown Jackson of a clear disclaimer indicating that government officials were posting on social media in their personal capacity, or I guess vice versa in their government capacity?
Certainly no doubt that legends would help at least us as constituents know what to expect. But the disclaimers could just be another form of a manipulation by the government official. They could say, I'm not speaking officially, but then speak in ways that actually are fully official. Or vice versa. They could say this official government account, but let me highlight some of my personal attributes and treat them as if they're a part of the government responsibility. And so the disclaimer doesn't really solve the problems that I think we have, but no doubt that if somebody portrays their account as an official government account without trying to walk it back or qualify that, I think the rule should be that we should hold them to that approach. But if they don't officially represent as part of their government account, it still might be part of their government function. And so the disclaimer is not going to be complete.
The Biden administration was backing the government officials' positions. They characterized the Facebook and Twitter feeds as private property. That seemed to me to be not a great concept here.
It's a really awkward conversation because we know that the social media services have their own rules. They have their own technological options that differ amongst themselves, and they have the ability to intervene with respect to particular items of content, irrespective of whether or not the Constitution would permit the government official to take that action. So they're like the elephant in the room. Everyone knows that the social media services are an integral player in this conversation, but they're not the plaintiff or the defendant. And as a result, they're not actually represented in this litigation. And as a result, the Supreme Court is likely to treat them as this opaque third-party player who is immaterial or inconsequential to the rules. That's actually a good outcome. I really don't want the Supreme Court talking about social media as a private entity or not. I don't want them making hard lines when that's not the question the government has to answer. But it's impossible to ignore the shadow that they cast over everything that takes place on their services.
The federal appeals courts reached opposite conclusions in the lower court cases?
That's correct. The Ninth Circuit held that the government officials, in that case school board members, were acting in their function as government officials when they blocked some constituents from accessing their social media account. In the Sixth Circuit, it was a government employee who had also blocked individuals. The court had held in that case that he was acting as a private individual. That was his private account.
So there were 3 hours, I believe, of oral arguments. Did you see some justices, some blocks of justices sort of coming to some conclusions, or did you see any patterns?
The short answer is no. Really, the oral arguments were quite opaque about where the judges are likely to end up, which is unusual, but one would have hoped that we would have been able to get a clearer line from the oral arguments. Having said that, there are two things that stood out to me. First is that some justices seem to be gravitating around the test that was advocated by the Department of Justice and was endorsed by the lawyers for the government employees about looking at the duties of the government official and their authority to speak on behalf of the government. And so Justice Gorsuch, for example, at one point said, it sounds like we got consensus, that's the right test. I don't know if there was consensus, but it wouldn't surprise me if the test looked something like that. At the end of the oral arguments, Justice Kagan, once again, had a really powerful turn of the phrase. She came and basically blasted the government lawyers, saying that the government lawyers' proposed test was really out of sync with the importance of social media to the government function and would limit the ability of us as constituents in order to be able to defend our own interests when the government keeps embracing social media. So I saw kind of two opposite approaches there. Justice Gorsuch saying, sounds good to me, let's go with the test that you proposed, and Justice Kagan saying that test is actually really harmful to the future.
Was there a split down ideological lines, or did this cross ideological lines?
I couldn't put together a pattern that represented any kind of ideological or partisan fit. But having said that, I would say that it seemed like some of the, quote, more conservative justices were more inclined to support the government employees' freedom to do what they want, whereas some of the, quote, more liberal justices were more skeptical about how that could lead to censorship.
So at times when we've had these oral arguments at the Supreme Court involving the internet, texting, social media, the justices have seemed to be a step behind, maybe more than one step. Did it seem like they fully grasped what was going on in these cases?
They really didn't. This was yet another example of how the internet baffles Supreme Court justices. And just to be clear, we don't know how many Supreme Court justices spend time on social media, but it's not like they do it publicly. So they're just not familiar with social media at the same degree that most of us as everyday users are. So it's not surprising that it's a little bit baffling to them if they're not immersed in that as part of their daily functions. But there was a really awkward line that came from Chief Justice Roberts, where he talked about social media and described it as the gathering of protons. And it was such a reductionist approach that social media is just about the movement of electronic pulses on the internet. That's all it is. And it's kind of like saying the Supreme Court's opinions are just ink on a piece of paper. It's a reductionist conclusion that isn't inherently wrong, but it completely misunderstands the scope and the stakes at issue in this case.
And this is the first of several social media clashes that are coming up this term involving the First Amendment and how it applies to social media companies.
So just to be clear, there's going to be a steady stream of internet law cases going to the Supreme Court and likely to be decided by the Supreme Court over the next few years. We've had just this upswell of legislation trying to regulate the internet, and many of those laws are going to end up before the Supreme Court. So we're just kind of at the beginning of this multi-year cycle where the Supreme Court is going to be regularly deciding the future of the internet. One of the other cases they've accepted, or there's two companion cases, involve the Texas and Florida social media censorship laws. These are laws that were enacted to basically take government control over the functional operations of social media. Sounds like the kind of thing that we would think would be clearly censorship, and yet the Florida court said that some of it was struck down, some of it was okay. The Texas appellate court said, it all sounds good to me. And so the future of the internet is very much at stake in that set of cases as well, because if the Supreme Court says that the government can dictate how social media runs its operations, they are going to be dictating what editorial decisions those services can make.
A lot more oral arguments on social media to come. Thanks so much, Eric. That's Eric Goldman, a professor at Santa Clara University School of Law and co-director of the High Tech Law Institute. Coming up next, Donald Trump looks for a get-out-of-jail-free card. I'm June Grasso, and you're listening to Bloomberg.
This is Bloomberg Law with June Grasso from Bloomberg Radio.
You're listening to a special Best Of edition of the Bloomberg Law Show.
And did you see today that deranged Jack Smith, he's the prosecutor, he's a deranged person, wants to take away my rights under the First Amendment, wants to take away my right of speaking freely and openly.
Donald Trump never seems to miss an opportunity to ridicule Jack Smith, the special counsel who's bringing charges against the former president in 2 cases in 2 jurisdictions. The trial date in D.C. on charges of trying to overturn the 2020 election is just a few months away. But Trump is looking for a pass by arguing he has absolute presidential immunity. And his attorneys have asked federal judge Tanya Chutkan to toss out the indictment. Joining me is former federal prosecutor Jessica Roth, a professor at Cardozo Law School. Jessica, tell us about Trump's claim of presidential immunity.
So their argument is that Trump enjoys absolute presidential immunity from prosecution because he claims that the indictment brought by the special counsel related to January 6th is based on what they contend are his official acts while president. I would submit this is the most significant motion that Trump has filed to date in all of the cases that are pending against him, and that the court's decisions on this motion could establish new law regarding whether a president is beyond the reach of the criminal law for acts taken while president, even after he leaves office.
What do you make of his attorneys' arguments? They make several levels of arguments. Are they convincing?
Well, the motion is well written, and unlike some arguments we've seen from Trump's counsel in some of the cases brought against him, this one is well written, it's well presented, and it does present a very important issue of law, one that the courts will have to take seriously. No court has ever squarely decided the question of whether a president enjoys absolute immunity from prosecution at all, because there's never been a precedent for criminal charges being filed against a former president. But there are 2 issues that the courts will have to address in ruling on the motion. The first is whether, in fact, presidents do enjoy absolute immunity from criminal prosecution for acts taken during the presidency. And if they find that there is such a thing as absolute immunity for president from criminal prosecution, then they would have to apply that doctrine of immunity to the facts presented in this case. If the courts hold that there is no absolute immunity for a president from prosecution even after they leave office, then they don't necessarily have to address this second question of whether or not Trump's actions fall within the scope of such immunity if they find that there isn't such immunity.
Trump's attorneys say the judge should look at Trump's actions on their face to determine if they were official, and also that even if they were a mix of official and campaign related, they should still be covered by the legal shield, the immunity. Do you agree with that?
So in asking whether or not the actions fall within the outer perimeter of the president's official responsibility, one has to ask at what level of generality do we look at the acts? Trump's attorneys invite the court to look at them at a very high level of generality and say these are statements on matters of public concern in his tweets and his public statements, for example, at the rally on January 6th. He is communicating with state officials about elections and communicating with members of the Department of Justice about whether or not the presidential election was conducted consistent with law. At that level of generality, it's easy to characterize his actions as within the outer perimeter of the president's functions to take care that the laws of the United States are faithfully executed. But when you look at a more granular level and also in context of sort of all the actions that are alleged in the indictment taken together, it's much easier to characterize them not as being within the outer perimeter of Trump's official duties as president, but instead as crimes or part of a course of conduct that was a conspiracy to overturn the election and obstruct the official proceedings of Congress and defraud the United States as alleged in the indictment. And so the case law does hold that the court should not look into the motives behind a particular action and instead look at sort of the acts objectively and whether or not they further a presidential function. But saying that the court should not look at motive does not mean that the court can't look at the statements and the actions in context.
Trump's attorneys also point to his acquittal in the Senate impeachment trial in the days after the January 6th attack and argued that he can't be tried again after the Senate failed to convict and remove him from office.
I do not think the court will agree with that analysis. The language that they point to has to do with, I think the court would find, whether a president could be indicted and prosecuted while in office. And if one goes back and considers, for example, the analysis in the Office of Legal Counsel memo that was prepared initially in 1973 during the Watergate era, which looked into whether or not a sitting president could be subject to prosecution while in office, that memo, which was then reaffirmed in 2000 by the Office of Legal Counsel, essentially held that because of separation of powers concerns, primarily, a sitting president could not be prosecuted, but instead would have to be subject to impeachment first and removed from office before the president would be amenable to criminal prosecution. What Trump's lawyers are doing, in effect, is taking that same language that provides for the impeachment of a president and then contemplates that a president could be criminally prosecuted after being removed from office, to say that the exclusive remedy for a president who commits crimes while in office is to be impeached, and that a criminal prosecution could only follow as an additional consequence if the president had been, in fact, convicted in the Senate. I think that's not a fair reading of that language, and I don't think a court would agree with it.
Has Judge Chutkan ruled on an issue involving presidential immunity before?
She has, in a different context. It was a case, I believe, involving former President Obama, who had been sued by individuals, and she held that he enjoyed absolute immunity from that civil action against him in his individual capacity. She has not ruled on a question of immunity from criminal prosecution. In a case that presents many of the same facts in the civil context, Judge Mehta from the D.C. District Court ruled that former President Trump did not enjoy absolute immunity from civil prosecution with respect to many of the claims in a case that was brought by members of Congress and members of the Capitol Police who were injured in the January 6th riot. That case is pending before the D.C. Circuit Court of Appeals. It's been pending since December. And that case, I think, will be very instructive to Judge Chutkan in ruling on whether or not, if she gets to the question of whether much of the conduct alleged in the special counsel's January 6th indictment falls within the outer perimeter of his official responsibilities. If the D.C. Circuit renders an opinion holding that it does not fall within the outer perimeter, that would be very instructive to her if she gets to that problem. Obviously, in the meantime, she may also find persuasive the ruling of her fellow judge on her court, Judge Mehta, that these actions largely did not fall within that outer perimeter.
Trump is the first former president to face a federal indictment, so this is uncharted territory. What has the Supreme Court ruled in the past in the area of presidential immunity?
So the Supreme Court has ruled on presidential immunity in the context of damages actions in civil suits. In the most important case is a case called Nixon versus Fitzgerald, in which the court said there is a doctrine of absolute presidential immunity that shields the president, even after he leaves office, from damages actions brought by individuals for actions taken within the outer perimeter of the president's official responsibilities. The court, in that case, drew on precedents from the context of other executive officials, such as prosecutors, but it also looked to immunity doctrine that the court had developed in the context of judges, other officials whom the court said would, if they were not provided immunity, would be potentially subject to damages suits.
Thanks so much for your insights, Jessica. That's Professor Jessica Roth of Cardozo Law School. Coming up next, what is a legal hot tub? I'm June Grasso, and you're listening to Bloomberg.
This is Bloomberg Law with June Grasso from Bloomberg Radio.
You're listening to a special Best of edition of the Bloomberg Law Show. We all know what hot tubs are, but what exactly is a legal hot tub? Well, it's not as exciting as it may sound, and it really has nothing to do with hot tubs. It's formally called concurrent expert testimony or a concurrent expert evidence proceeding, and it's like a discussion among experts. but it's not very popular in U.S. courts, at least so far. Here to tell us about it and how it got that name is Bloomberg law reporter Dan Papskin. So tell us exactly what this legal hot tub is, Dan.
You can kind of think of it as a debate between experts, often economic experts, but not necessarily, where instead of one sitting on the stand in a trial or in the pretrial hearing and getting examined and then cross-examined by one side's attorneys and then the other, both or all of the witnesses sit together before the judge and are basically prompted to debate each other on a series of predetermined topics or questions.
And where did they get the name hot tub for this?
Australia. These originated pretty much right around the beginning of the decade, and it was deployed originally by the Australian Competition Tribunal, since they're kind of antitrust dedicated court system, basically to get a clearer understanding of what experts were talking about and make them really drill down on their agreements and their disagreements. It was pretty successful there, and it's taken off in a bunch of other countries, in Europe, in South Africa. Canada has used it. It's mostly been unpopular in the U.S. We've only found a little less than 24 instances of federal judges using one. It hasn't taken off.
Maybe the name has something to do with that. I know you witnessed one of these legal hot tubs when federal judge James Donato held one in San Francisco. So tell us about that.
So Donato held the second hot tub he's held in this case. This is a lawsuit alleging Google basically has anti-competitive control over the payment systems in its Play Store. And so the second hot tub was to basically determine whether the plaintiff's experts have reached kind of valid models for figuring out how much consumers were harmed by these Play Store policies and what the impact was on the market.
Is the judge the only one asking questions, or are the lawyers asking questions? Is there crosstalk between the experts?
There's a lot of crosstalk. It's almost exclusively Donato asking the questions. He allows a couple attorneys to sit with the experts in the hot tub, but they're really only allowed to ask questions right at the end if they have kind of clarifying questions for either expert. Otherwise, Donato prompts one side or the other. We'll say, like, yeah, I read your report. I had this question about this, one part of the model. And then we'll prompt the other expert to be like, do you disagree with that? If so, why? It got pretty heated several times. There was, I don't know if you would call it yelling, but definitely raised voices. The court reporter had to interrupt, I think, 3 separate times because 2 experts and the judge were talking over each other, and she, couldn't transcribe that in real time. So it definitely is a little more chaotic than your average courtroom testimony.
Is this because the expert testimony is so complex for the judge to understand, or is it because this is quicker? I mean, what's the real reason behind this?
The reason Donato held the hot tub was to answer this Google motion over whether the experts should be allowed to testify or not. And Donato told me in an interview afterwards that it's very useful for him understanding their testimony and their models. It is really complicated, and that's a big reason why judges are deploying hot tubs, although they haven't deployed too many of them. But it's not just about the complexity. It's also faster, Donato said. It's a lot cleaner. He compared normal expert testimony, non-hot tub testimony, to a game of telephone, right? You've got the expert on the stand, you've got their attorney questioning them, and then you've got the judge hearing their answers. So it's kind of filtered through what questions the attorney wants to ask and then how the economist in this case answers those questions. So the judge might not necessarily be getting the exact answers they're looking for.
Well, we'll see if the use of these legal hot tubs picks up, but I think a name change is in order. Thanks so much, Dan. That's Bloomberg legal reporter Dan Paskin. This is Bloomberg Law on Bloomberg Radio. I'm June Grasso. Stay with us. Today's top stories and global business headlines are coming up right now.